Hi folks, welcome to Keeping It Real. I'm your guest host, Tariq Sultan from Remix Dynasty Realty, Inc. Now we have invited Mr. Abdul Hamind, barrister and solicitor. He's one of the famous lawyer and very well active in the community, and he's known as, one of the best lawyers. So I would say thank you very much, Mr. Abdul Hamind, for taking out your time and being with us today.
Thank you very much, Tariq Sultan, for inviting me. Thanks.
Thank you. Mr. Hamind, I have a couple of questions. As myself as a realtor, I would like to know that what is the role of the lawyer? What do they do most?
If you're asking what the lawyers do in real estate transaction.
Absolutely.
Normally lawyers do many things, in this country, but when it comes to real estate, it's very important to have a lawyer because you cannot complete a real estate transaction without retaining a lawyer. That's the law, because a lawyer has access to the registry office, they have access to the searches, they have access to the other information, which you need to make sure that you are protecting your client who is purchasing the property. So this is the one part where the lawyer, they do their due diligence to check the title of the property. The second part is to deal with the money, because lawyers, they have the trust accounts, so they have to deposit the mortgage funds and they have to deposit the down payments into trust and to make sure that the transaction is going to be completed. So if something happens, then obviously this is the money coming from the purchaser or coming from the bank, so they would return that money or whatever the situation would be. So it's a very, very fundamental and vital role for the lawyers in real estate transaction.
Wonderful. We understand that, but could you kindly put some light? Because we as a real estate agent always say to our client as well, that put the if you're going to put the offer, right, it should be reviewed by the lawyer. Or you can also make it, contingent, so that the lawyer can review it, because then after that, there shouldn't be any surprises. What would you say about this?
Most of the agreement, as you know, is we see that they are very standard agreements. And there are few things which you put, like financing clauses, survey clauses, things like that. So in practice, I would tell you, most of the people, they don't ask lawyers to review, because the real estate agent, they sign the agreements in their offices, they explain to the purchaser or the seller. But I would always strongly recommend that you ask a lawyer to look at it, because there could be many things, hidden things, a clause missing, some dates, something like that, not properly executed by the both parties.
Absolutely.
Amount of the deposit, how much is the deposit, sometimes is very vital also. If the transaction is not going to be completed, then there might be a dispute on the return of the deposit. So there are many things, and since you are retaining a lawyer to complete your transaction, then I don't see any reason why you should not ask him to review your agreement of purchase and sale.
Great, wonderful. Another question out of your conversation regarding the survey, because most of the buyers, they don't understand how vital it is. So would you mind to put some light on it as well?
Yes, of course, it depends on the property, where the property is located. Nowadays, most of the lawyers, what they do, they get the title insurance. Most of the transactions are title insured. Title insurance will cover any defect which goes to the survey. Most of the title companies, they even don't ask you to get the survey. They cover it, blanket coverage. But I would still say that survey is very important, because there are two things. One is the responsibility of the lawyer, and one is the safeguard and protections which you are getting from the real estate insurance companies, title companies. But that does not give an excuse to a solicitor to not do his job. For example, the title company is covering me for a defect in the survey. But under the law society rules, I should be asking for the survey and I should be reviewing the survey to make sure that I am fully complying with my responsibilities as a lawyer, right?
Right.
So that will give kind of double protection to my clients. Once from the title insurance company and one I have seen the survey. If something happens, for example, my client wants to put the fences or there is any other issue, I think that would require.
Because mostly they say, when you want to do the alteration or any extension, right? So if you have to have a survey.
Exactly.
So that's what it is. That's great. Another question comes to my mind is regarding the deed. How the deed is that important because you have to, transfer you have to, get the deed and the title transfer the information of the buyer. So with that perspective, if you could put some light on it as well.
Normally, in this country, this is a public knowledge who owns which property. Any solicitor or anybody who has access to the TerraView system can go and check actually, for example, if you own a property, right? You can also go there if you have access in TerraView, or you can personally go to registry office and ask them to print the deed for you. So basically, deed, if you're talking about a document, is not that important to have in your hands. Even though if you do not have that in your hands, it would be still sitting in the registry office. So anytime when you need, you can ask for printout. But deed as a legal document is the fundamental document which you need to transfer the property, because that's where we transfer the property from the seller to the purchaser.
Right.
So that's the only document which shows your ownership, that the property has been transferred on such and such date from such and such person to such and such person.
Right. So the question that arises, when we say about the deed, so it means that as a lawyer, is it your foremost responsibility to find it out that, there is no lien or anything against the deed? Is that so?
As I said in the beginning, that the most important responsibility of a lawyer to do the searches on the property, to make sure that the title is clear. And if there is a lien, if there is a claim, if there is a court order or something like that sitting on the title, that means title is not clear. So when I do the search, I prepare the requisition letter in which I would mention all the defects or issues related to the title, and I would ask the vendor lawyer to clear that before he can transfer the property to me. So that's why when we say the clear title or clean title, that means it has to be free from all kind of claims, liens, everything. Yes.
Okay, wonderful. That's great. So would you please tell us something regarding the buyers, when you do the buyer closing, how does it's going to different than the seller's closing?
As a lawyer, I think when we are acting for the purchaser, then we have kind of double responsibility, because we are acting for the bank as well as for the purchaser.
Right.
So that double responsibility means that if there is no conflict between bank and the clients, we have to make sure that both clients are protected. The bank is protected, there is no fraudulent transaction, there is no material fact which we should be reporting to the bank which would adversely affect the mortgage. At the same time, we have to protect our client and to explain to him if the terms and conditions of the mortgage are fair, interest rate, everything we have to explain to them. So it's like more complicated when you are acting for the purchaser. Comparatively, when you are acting for the seller, you do not have that much responsibilities. Obviously, you have to do two things. One, you have to get the mortgage discharge or any liens or claims or anything clear from the title, and just to transfer it to the purchaser. So sale side is simple transaction.
Sale side is simple transaction. Okay, is there any fee structure? I mean, is it any different when you charge from the buyer or from the seller? I heard that.
Yes,
why this is so? I mean, if you
because of the disbursements. When we are acting for the purchaser, we have to spend money on the searches.
Right.
To make sure everything is clear, we have to certifications of checks, couriers. There are many small disbursements, which are a lot more than when we are acting for the sales side.
Right.
Yeah.
Mr. Hamid, another thing, out of curiosity, I just want to know, because I do diligence to all of my clients, and I strongly recommend them that you also should have a will. So what would you say about the will? Why it is that important, especially under the Canadian, the common law act?
Well, in this society, anybody who owns some kind of property and is a married person or have children, obviously you have to make sure that if you are no more by chance, then your property is not a problem for the people who are going to be the beneficiary. Problem in sense that if you do not have will, you die without will,
right,
then your children, they have to go through the court process,
right,
to prove that they are the beneficiary. And it's a long process. You have to apply in the court and then follow the process to complete that, and ask the judge to order that these are the beneficiaries. And then you go to the registry office and you transfer your property or go to your bank account or any other place. That process is painful, is lengthy, and is very expensive, especially for the family who is just going through a kind of painful process of death. So to avoid that kind of complicated and expensive process, all you have to do is to write a will.
okay,
But I can tell you one very important thing on will, that most of the people who are writing the wills is actually nothing. They are writing nothing at the end of the day. When they go to the people, pay $200 or $300 and get a will prepared for them,
right,
they are getting equal to nothing, because that will, most of the time, will not be acceptable in the court of law. Because once you make the will and once you die, after that you have to go through the court to validate the will. And if you do not have all the requirements in it, for example, it has to be written in proper way, it should not be in contradiction with the family law, with the law of Ontario or wherever the jurisdiction you live in.
right, right.
It should be witnessed by two witnesses, and not just that, it has to, two witnesses should give their affidavit, the separate affidavit that we saw this person signing this will. And then it must be notarized by a solicitor. If you go on the website or you go to the court on documents, and you will see the requirement for a valid will. They will show you that if there is one thing missing, it's not notarized, it's not with two affidavits, they are not going to accept it. So you wouldn't be there to rectify that error.
Oh, God.
So that's the only place where you cannot do anything. So I would advise that if you are looking for a will, you must go to a lawyer. And if you are expecting to make a valid and good will for $200-300, that's not real. So you have to spend at least $400-500.
Okay.
It should be an experienced lawyer. I'm telling you, nowadays, 10 years ago, most of the claims going to the Law Society or Law Pro against the lawyers were real estate, because of mortgages and frauds and all that things. So now the title companies, they cover you.
Okay.
So they minimize the claims. No, most of the claims against the solicitors are for will, for making will, incorrect wills, things like that. So the person has to be experienced, and he or she should know what they are doing.
So it means, because it's really great information, I would say, because most of the clients, they go for the kit of the will, they buy it maybe $30, $60, and they said it could be just written on a piece of paper, but it will be valid and current as well. So after having a conversation with you, I understand that it got to be current and notarized as well.
I can tell you, the will which you buy from what do you call it, business depot,
yes,
like
yes, yeah, that's right.
Instead, if you write a handwritten will, that would be more credible, because that's your handwriting.
Oh, okay.
And if somebody challenge, you can always ask for expert people to see if it's your signature or not, if it's your handwriting or not. But this kind of will, I don't mind. There are many people, they are making their living out of making wills like that. But what I'm saying, that I'm saying through my experience, and that I'm saying by looking at the number of claims against the solicitors in the law society because of these defects in the wills.
Right. Wonderful. That's really great information. So, I mean, another relevant question it does arise is regarding how to probate the will. Probating will
probating will is very simple process.
Okay.
There are two ways to do it. One,
Right.
you retain a lawyer or paralegal to do it for you,
Right.
or you go yourself, you fill up a form and you
Mhm.
submit the will
Mm-hmm.
in the court, and they will do it and they'll mail it back to you in 2-3 weeks. It depends in which jurisdiction you are, how busy the place is and things like that. But if the will is valid
Right.
itself, then probating a will is a very simple and straight process.
It's not cumbersome then.
No, no, not at all.
Wonderful. That's great. Okay. I mean, I would like to ask you if you can give a good piece of advice for the buyer or for the seller as well. So would you mind to say something about it, you see?
Well, I think that's your field.
That's right.
Because people, they start from
No,
you
we
and
always
then they
recommend. We
come to
always
us.
recommend a good lawyer.
Yeah, but
Right.
I would say that as a lawyer, I would again stress upon the point that they should have a good lawyer to complete their transaction.
Okay.
Lawyer should look at everything starting from fraudulent transaction to, you know, all kind of mortgage frauds, all kind of ID frauds. There are 100 of things which I can mention that the lawyer should be looking at that.
Right.
Therefore, the lawyer should have experience, and the more experience you are, more you understand the complexity and you can handle the transaction smoothly. So if you are in good hands, then you shouldn't have any problem as a buyer or as a seller.
I would say it's a great piece of advice. Oh, that's wonderful. And
again, I would
yes.
add one thing, that if you are
Please.
cutting the corners on fee and you are going to retain a solicitor for
Absolutely.
$300,
Right.
then you should be
Willing to pay the
careful
price.
about that. Yes.
Oh, okay. That's great. Okay. So thank you very much, folks. And I would say, thank you very much, Mr. Abdul Hamind,
Thank
for
you.
coming here and giving us a great information which will be beneficial and educative for all the consumers, whether they're buyer or the seller. So keep on watching. Thank you very much.